Mr. Pomfret.
May it please you, my lords, in this matter I appear on behalf of the appellant with Mr. Laurel and Mr. Chai, and then friend Mr. McElroy appears with Mr. Darrell, the respondent. I'll begin, if I may, by expressing barrister in the room's gratitude for dispensing with robes today, and so we're all grateful to you.
Not at all. I think it seems to be quite comfortable in here.
It does, thank you. I should begin with some housekeeping, not least because one of your associates mentioned that there may be an issue with bundles before the court. We apologise for that. The parties have cooperated to try and make sure that the right papers before the court. What you should have, my lord, is a core bundle, a supplementary bundle,
yes,
and a combined authorities bundle.
Yes.
You should have those in PDF form, and also hard copies were filed yesterday. There were earlier versions filed, and the difference there was the core bundle has simply been updated by the two documents at the end, which is my supplemental skeleton and my learned friend's supplemental skeleton. The authorities bundle has been updated by the addition of the two authorities at the end, which are Professor Lowe's article and the Cameron and Victoria insurance case. I hope if anybody had started any work with the prior bundle, that helps in the sense that the page numbers won't have changed up to where those additional documents have been.
All right. Well, let's do it by trial and error. I mean, I think you've got it as far as you can, and if there are any difficulties, they'll become apparent, and we'll let you know.
I'm grateful. I've spoken to Mr. McElroy. I'll aim to make sure that I don't speak for any longer than 2 hours. That leaves him 2 hours, and then half an hour for any reply. If we can get through it quicker, I'm sure everybody will be grateful to us if we do.
By all means.
My lord, you'll appreciate the supplemental skeleton was added last week. It's been provided to assist where I was only instructed last week. I hope it is of assistance. The grounds of appeal do remain the same, although I would accept they were capable of more concise expression. In a nutshell, they come down to saying, with respect, that Judge Pearce misapplied the test in Rule 40.9.
Sorry, I'm just going to need you to speak a little bit louder, and so you're going to tell us the grounds in a nutshell.
Yes, my lord.
Right, that's going to be helpful.
First, the judge misapplied the test in Rule 40.9. Second, he failed to give effect to the fundamental principle that we've identified in our skeleton, paragraph 7, that a person cannot be subject to the jurisdiction of the court without having notice of proceedings. And I say that's not a mere technical point in this case. But Kyrrex, the appellant, should have been a defendant to this application, or to Mr. Jones's claim and application. Third, the judge was wrong to hold that Kyrrex's position would fail on the merits were the judgment set aside. And fourth, to the extent the court had a discretion.
Sorry, three,
the judge was wrong to hold that Kyrrex's position would fail on the merits.
Yes.
And fourth, to the extent the court had a discretion, and we accept that it did, it exercised it on a logically flawed basis as to merits, as to delay, and as to prejudice. My lord, am I fair to assume that the court has some familiarity with cryptocurrency cases and the terminology that's used in those cases?
Go ahead on that basis.
I'm grateful, my lord. By way of introduction then, I say, as set out in our supplemental skeleton, the crux of the position of the appellant is that the court below refused to set aside the order of Mr. Cooper King's counsel, directing a crypto exchange, Huobi, to transfer Bitcoin from a particular wallet to Mr. Jones, notwithstanding that, as the court below in fact held, the judgment of Mr. Cooper was wrong in two crucial elements. First, it was wrong to attribute any cryptocurrency from Mr. Jones, any Bitcoin from Mr. Jones, as ever having arrived in the wallet that's been called the T-Held wallet. Secondly, in saying that the Bitcoin in that wallet could only have been transferred there by Mr. Jones's fraudsters. Now, Huobi nevertheless complied with the order, transferring to Mr. Jones 98 Bitcoin. But the problem there, my lords, is that because of the misconceptions at 1 and 2, this necessarily involved transferring cryptocurrency Bitcoin to Mr. Jones that wasn't Bitcoin that had come from him originally and must necessarily belong to a third party. Kyrrex was the...
When you say necessarily belong to a third party?
Yes.
Who was that third party?
Well, anybody else who had cryptocurrency, anybody else who had Bitcoin in the wallet.
Yes, but don't you have to establish that, I mean, leaving aside any other difficulties that may arise, don't you have to establish that that third party was you?
Well, we say we do establish that.
Right, so you're going to show how it is that it's a clear inference that the Bitcoin that went was yours, rather than simply it being part of a larger fund that belonged to a large number of people, if belong is the right word.
Yes, 2 points to that, my lord. One is Judge Pearce held that it was our Bitcoin that was debited to enable the transfer to happen. Second, and on the evidence, that was a perfectly reasonable finding. Secondly, my lord, we say, well, actually, to set it aside, we only need to be part of the class of persons who could have been affected by the order. So once it's established that the Bitcoin doesn't belong to the fraudsters, because it's fraudsters, that's what I mean by third parties.
Right, but I was interrupting because simply to say that it belonged to a third party wouldn't in itself be enough for you, would it?
No, no, my lord.
You have to at least be part of the class of third party.
Exactly, my lord. And we say on Judge Pearce's findings we were part of that class, and on Judge Pearce's findings we were actually the person whose Bitcoin ended up being debited. And
so when you say that the judgment of Mr. Cooper was wrong, you don't say that in a critical sense. You say that that there was information which led to the judgment being as it was, but subsequent investigation has shown that there were different facts.
Yes, exactly, my lord. No criticism of Mr. Cooper. In fact, as I'll come on to show, what he thought he was doing was exactly what one would normally do in a cryptocurrency case, which is you have D2 and D3 who are believed to be the persons who are actually holding the Bitcoin. So Mr. Jones says, Bitcoin's been taken from me by fraudsters. It's gone somewhere else. Those people are either the fraudsters holding it, or people with notice of the fraud, or they are innocent receivers, and that was D2 and D3 respectively. Now, on the information that was put before Mr. Cooper, he understood that that was right, and that it must be the fraudsters, because only the fraudsters had Bitcoin in the wallet. Had he appreciated the correct position, which is that in fact Mr. Jones's Bitcoin never reached the wallet, except perhaps for a very small amount, which we say the evidence doesn't bear out, then he would have made a different order in terms of D2 and D3.
Right, so I appreciate I'm testing my understanding, not making any assertion, but you're describing a situation in which Mr. Cooper thought he was simply restoring the money from the fraudster to the owner.
Correct. And it's all based on an expert report from that was before the court, but was subsequently disavowed by the respondent on the application before Judge Pearce, having been analysed by Simon Davison, and I'll take you to that report in the course of my submissions.
Just in terms of the structure of it, ordinarily when you're applying to set aside and it's not as of right, you have standing, arguable defence and discretion. Am I right that the issues as to whether the judge was, as it were, proceeded on an incorrect factual basis that was put before him goes to the second of those issues in many ways, which I don't understand to be an issue on this appeal?
I think that must be right, my lord, yes. But in my submission, it's helpful to show why the order should be set aside and why the discretion is a narrow one, to show that in fact even Mr. Cooper wouldn't have made the order in the first place had he have known the true position.
Yes.
And that, I say, the consequence of that is what's been done is a clear injustice. And once we show that no Bitcoin of Mr. Jones reached the wallet, the order should almost as of right be set aside, subject, of course, to what I say is a narrow discretion.
Yeah. Well, I can see the stronger the argument, that might weigh in at the discretionary stage as a fact.
Yes. So there's a point that the respondent takes that I'll come on to in a bit more detail, which is say, well, in actual fact, Huobi the exchange didn't transfer Bitcoin directly from the T-Hell wallet, but from a different wallet. I say it's unrealistic to say that that makes any difference. It's no different than a bank transferring it from a general fund and then debiting your account. Everyone accepts that Bitcoin is fungible, and it doesn't really make any difference whether it's particular Bitcoin or not, save that it makes a difference to why Mr. Cooper made the order that he made. So because Kyrrex wasn't a party to the claim, we engaged this fundamental principle identified at paragraph 7 of the skeleton argument. And it's engaged in this particular context of person unknown cryptocurrency cases, which is a busy and developing area of jurisprudence. And although in fact what ended up happening was that Kyrrex wasn't a person unknown because it hadn't received any of Mr. Jones's Bitcoin, it's a vivid illustration of how easily that person's unknown jurisdiction can go wrong in this context, where the court's misinformed about the tracing exercise and about where the Bitcoin's gone. The judgment and order proceeded on the basis, I've said, that in fact Mr. Jones's Bitcoin had been traced to that particular wallet, and therefore that D2 and D3 would capture the person's unknown, but it didn't because the expert evidence was mistaken. So I got the order of Mr. Cooper, King's Counsel, and Judges Pelling KC and Burke KC before him, those were the interim orders, were mistaken substantively in that Mr. Jones's Bitcoin hadn't reached the T-Hell wallet, and also procedurally in that once the wallet didn't contain only assets transferred by Mr. Jones's fraudsters, that undermined the whole basis on which the interim orders were served against persons unknown, because it targeted the wrong persons unknown. And it also permitted alternative service on D1, 2 and 4 by email, which was never going to reach Kyrrex. So given the fundamental errors at the heart of the judgment, what I say is that enforcement of the order was always in fact going to involve someone having their Bitcoin expropriated to ensure that Mr. Jones was paid, and that someone ended up being Kyrrex. And that someone must be entitled, within the scope of a narrow discretion, to do otherwise, to set aside the order and have their day in court. I say the fundamental principle and natural justice requires that the order is set aside. So I have a number of items to take you through on my agenda. First, I'll look briefly at the cryptocurrency persons unknown context. Second, I'll look at Mr. Jones's pleaded case and the court orders, including the interim orders. Thirdly, I'll look at an argument that's made on service by the respondents. Fourthly, we'll look at Mr. Cooper, King Counsel's judgment. Fifth, we'll look at the undisputed facts for the purpose of this application, for the purpose of the set-aside application and this appeal. Sixth, at the areas of remaining disagreement, having looked at my learned friend's supplemental skeleton argument. And then, seventhly, look at the test under 40.9. Eighth, whether Kyrrex was directly affected. Ninth, discretion. And then lastly, the order is appropriate on this appeal. So first, the cryptocurrency context. My lords, this may be the first time that the Court of Appeal has had to consider the merits of such a case in the sort of 7 years or more that these cases have been coming before the court on an interim, more regularly on an interim basis, but also quite often on summary judgment basis as well. Rarely reaching a trial, although there is the DLO case to which both parties have referred, which reached trial, and failed because Mr. Farnhill, sitting as a deputy judge, held that the expert evidence didn't show that the cryptocurrency had actually been traced into the right wallet. Because it's an art as much as a science, one has to decide whether to apply FIFO, what happens with commingling more generally. It's not so simple as just being able to show a straight line, usually. Although comparisons, my lords, can be made with the protester cases of persons unknown, the problems in serving persons unknown are different in crypto cases. In protester cases, it's a question of affixing something to the area where the protest might take place, amongst other measures. and that's been considered usually adequate to bring the notice of the injunction to the potential protesters. And for that, you could see the shell case that's in the authorities bundle at paragraphs 200 to 209. In crypto cases, my lord, email or dropping what's called an NFT into a wallet has become the accepted means of alternative service, along with CE filing at court. But whilst those might work, well, the first two of those might well work in a case where the wallet is controlled by a private individual, there are problems with it in a case like this, where it's a custodian who controls the wallet. So it's not actually the person whose Bitcoin is in the wallet that controls the wallet. They don't have visibility on the wallet, so they won't necessarily see an NFT that's dropped into the wallet. They won't receive an email that's sent to the exchange. And so alternative service becomes much more difficult in those cases like the present. The other point to bear in mind in my submission is that the law is still at a very early stage of its development in terms of forensic following and tracing of cryptocurrency, with the DLO case I just mentioned and this case being vivid demonstrations of how it can be unreliable. That increases the risk of unjustifiable orders against persons unknown, or in fact, third parties who aren't even within the class of persons unknown, as Kyrrex was in this case. And I've put before you, my lord, an article of Professor Kelvin Lowe, a case comment on the decision below, which analyses those problems and how they make the decision below in this case unsatisfactory.
My recollection is that refers to an earlier case note on Mr. Cooper Casey's decision, which I think it would be worth people having a look at.
Very well, my lord. I think there may be a note by Channon Lowe that...
Yeah, maybe that's the one I'm thinking of.
I'll make sure it's before the court. Thank you. I'll take you then, with those comments about the cryptocurrency in the persons unknown context, I'd like my lord to take you to the Mr. Jones's pleaded case next. And I'll do that by reference to the supplementary bundle. And we start at page 12 of that bundle.
Is there anything new in the new supplementary bundle that wasn't in the old supplementary bundle?
There shouldn't be, my lord, no.
So we can use the one that we've been reading?
Yes. It's only the core bundle that would change. Oh, well, and the authorities bundle, of course.
Thank you.
So if we go to page 12, we see paragraph 2. Now, D4.
Which page?
Page 12, my lord, please.
Thank you.
Huobi, the fourth defendant is Huobi, which is the custodian that controls the T-Hell wallet. The claim against it is set out in paragraph 2, first of all, saying it's as the receivers and holders of the claimant's assets on constructive trust. And it then goes on to say that the Bitcoin has been traced at paragraph 4 into that wallet. And we now know that's not right. Paragraph 17, again, which is page 14, is about the fourth defendant having control of the wallet and therefore holding the property as an equitable constructive trustee. And paragraph 19 to 21 deal with the expert evidence that was relied upon at that stage.
Can you explain to me what the words "or its traceable division" in paragraph 17 mean?
Yes, well, I can do my best. It isn't my pleading, of course,
I understand that.
I would interpret that, my lord, as meaning it may contain the Bitcoin itself that was transferred from Mr. Jones, or it may contain other Bitcoin that has been acquired with that along the way in a way that it can be traced rather than followed.
Yeah, that's how I read it.
So, in this terminology, which I think was endorsed by Lord Millett once,
Yep.
Following is where you identify someone holding what was always your property. Tracing is where you identify someone holding substitute property that's been acquired with your property.
Exactly, my lord.
Yes.
I think, as Millett said in that judgment, in many cases the words are actually used interchangeably.
Yes, he complains that people use them loosely, but that's the distinction that he draws.
I won't say too much about that because if you look at my skeleton too closely, I've probably misused them in places. But the two are distinguishable in that sense. And one can see why they've made that distinction, because when one looks at Mr. Davison's analysis of their expert report, one can see that to the extent an exercise has been done to follow or trace Mr. Jones's Bitcoin, it purports to be what would be a tracing exercise in many places rather than a strict following. It looks at Bitcoin going into one wallet and then Bitcoin coming out of that wallet into the T-Hill wallet and says, oh, well, that will be the same, which is a type of tracing.
And I assume that, I think there's a reference in one of the skeletons to gold bars stamped with a number. Bitcoin doesn't come stamped with a number. You can't say, here's my number, that's my Bitcoin. You have to say, it went from this wallet into that wallet, and then it went from that wallet into that wallet, so that's my Bitcoin. And of course, as soon as you go into a wallet where there's more than just your Bitcoin, it becomes a difficult and contentious exercise.
That's right, my lord. As I understand it, what Bitcoin is effectively is an entry in the universal blockchain ledger that identifies a particular transaction, and then with your public and private keys you can then access that to deal with it. But
all the ledger shows is that X amount of Bitcoin is sitting in a particular place, isn't it? Does it show any more than that?
Or the transaction that put it there.
Yes, and the whole chain of transactions, right back to the origin, that put it there. But it doesn't identify a specific Bitcoin.
Well, it's fungible. So yes. One Bitcoin could be repaid by a different Bitcoin.
That I'm sure may be the case in that sense, but certainly Professor Fox's view is the unique transactional history recorded in some crypto coins, such as Bitcoins, may mean that it can never be mixed in an absolute sense. And I think that's the effect of the judgment, the evidence recorded in Mr. Farnhill's judgment, is it, that it can be followed, or at least in some cases it might be possible to specifically identify, yes, this is the same Bitcoin, not a substitute for it, and I'm able to trace through intermediate stages. So that might be a more controversial question.
Yes, not one that we say matters for the purposes of the present appeal.
I don't know if the court will be assisted at this stage with my understanding of Bitcoin.
Well, could we? I'm trying to follow the thread. Thank you, but will you pick it up when it's
Of course,
when it's your turn?
Going back to the statement of case of Mr. Jones, if we go to page 16, paragraphs 19 to 21 then set out where the expert evidence Mr. Jones says got them to, which is that his Bitcoin was in the T-Hill wallet, and that address, paragraph 21, has been identified for the scammers who are the first and or second defendant. Off the back of that, Mr. Jones then obtained, in the usual way, interim orders. He obtained a proprietary injunction which starts at supplemental bundle page 97, a freezing injunction in more like a Moraver injunction.
Just the interim orders, firstly, proprietary injunction.
Yes, that's at 97.
Thank you.
The freezing injunction, as it's termed, is at page 113. And there are ancillary orders for service and information, and they're in between the two at page 106 to 112. And I just wanted to point out a couple of provisions of those orders. Starting at page 98 in the proprietary injunction, paragraph 1.3, where the court held that the stolen assets are 89 Bitcoin, which have been transferred into the following wallet address. So that was the basis on which the court was acting at this stage. It says for
what is that? It's not a finding of fact after a trial. This is just ex parte application.
It's a curious provision to be in such an order. I accept.
Is it a declaration? Is it an interim declaration? Is it I'm making this order on the footing that? What is it?
In my submission, it's showing the footing on which the court has made the order.
Yes.
It can't be a finding, of course, because it hasn't heard evidence from both parties. It must be a finding that there's a prima facie case that enables the court to exercise its interim jurisdiction, applying the appropriate test on a proprietary injunction, which, of course, Americans say animate. But it then goes on, my lords, to refer to the fact persons unknown are divided into three categories. Those involved with fraud, those who've received assets without having paid a full price, and innocent receivers. And it says at 1.5, for the avoidance of doubt, this order does not affect innocent receivers. So in other words, D3, even though D3 is a party, is not actually affected by the order.
It's not clear to me what D3 is doing in the action at all. Is any relief at any stage sought against D3?
There's nothing set out in the particulars of claim. It appears to me, my lord, that the D3 is there simply as a placeholder for a tracing exercise. Bearing in mind that there's an interim injunction here, so D3 I'll put there as, well, they may be people who the money's traced to.
Yes, but they're not told to hang on to the money in the meantime.
No, the order doesn't apply to them.
Exactly.
Yeah. Paragraph 2.3 of the order then goes on to identify the particular wallet, which again is a T-Hell wallet, saying it was a wallet used, 2.3.1, used by the first respondent scammers. Then at paragraph 4...
A figure is there offered for the value of the wallet at that date.
Yes, my lord. Paragraph 4, variation or discharge of the order. It's the usual provision, but I say it's a significant one in the context of this case. Anyone served or notified by the order may apply to the court at any time to vary or discharge it. That, of course, would cover Kyrrex when it came to know about the order. And at page 103, within the undertakings, there is the usual undertaking that the respondent will pay, the applicant will pay the reasonable cost of anyone other, this is undertaking 4, usual cross undertaking and damages to anyone affected by the order, other than the respondent. And again, I would say that's someone that Kyrrex subsequently falls into that category. We have the order for service and information at page 106 to 112. And what's significant in here is that Judge Pelling at this stage is ordering that Huobi make certain disclosure of information in relation to who is entitled to the Bitcoin in the wallet. And there's a Schedule 1 and a Schedule 2 setting out the information that Huobi is obliged to provide at page 110 and 111 over to 112. And it includes the persons who hold the relevant Bitcoin, persons who have accounts in the wallet. But that order was never complied with in terms of the information. Paragraph 5, my lord, to your point about the third defendant, so going back up to the body of the order, page 108, is where we find the order for service, and the paragraph 5 is the provision.
So which page are you now reading from?
Page 108, my lord.
Thank you.
This is the freezing order, is it?
No,
This is a... So,
disclosure.
yeah,
A disclosure order.
Judge Pelling made 3 orders on the same date.
Right.
He did a proprietary injunction, what's been termed a freezing injunction, and then an ancillary order for provision of information and service in respect of all 3 orders. And I'm looking at the paragraph in relation to service, which is 5 on page 108. And what's provided is that the first, second and fourth respondents can be served by alternative means, which is email and WhatsApp, as well as filing at court. Nothing is said about D3, so D3 isn't served at all, or there's no alternative means for serving D3. And that, of course, would require Huobi to comply with the provision of information order to know who may be D3 so that they could be served, or indeed who may be D2 if it isn't D1. But Huobi didn't comply with that. There's I don't need to take you, I don't believe, to the freezing injunction. It contains what one would expect, equivalent provisions to the proprietary. There's a return date order made at page 122, and that has the same provision for alternative service of D1, D2 and D4, and it doesn't address the fact that the fourth defendant hasn't complied with the provision of information. So D3 and the proper D2 is still not served. Then we come on to Mr. Cooper's order on the summary judgment application, which is at page 134. And in the recitals, the judge said that the court was satisfied that proper service of the claim form, etc., has been effected by the claimant on each of the defendants. Well, of course, it hadn't been effected on the third defendant, but he does then go on to say in the next recital, for the avoidance of doubt, the third defendant is excluded from the scope of this order. Paragraph 2 provides for delivery up from the wallet, the T-Hell wallet, under the control of the fourth defendant, on the basis it's been used to store fraudulently obtained Bitcoin, including those belonging to the claimant. Say that required to deliver it up by making a transfer. And then paragraph 3 is actually the delivery up order itself, saying that the sum of 89 odd Bitcoin be transferred from the T-Hell wallet to Mr. Jones. And again deals with alternative service at paragraph 6. And also provides that at paragraph 9, the costs of the action be added to the Bitcoin that's to be transferred. So that's how we end up at 98 of Bitcoin.
It's an order for payment of costs in a non-fiat currency, which is a first for me.
Yes, my lord. So that's how we end up with 98 odd. Now, paragraph 6 gave permission for the order to be served on D1, 2 and 4 by alternative means, including email and dropping an NFT into a wallet. Now, in my submission, that shows that the court thought that that would be adequate for service of D2 and also D3, in fact, although they're excluded from the order, on the basis it had been told that Mr. Jones's Bitcoin was in the wallet and that it had been transferred there by the fraudsters. Otherwise, my lords, the order would be prejudicial to D3, which was expressly excluded from the scope of the order. And in my submission, that's also reflected by the fact that paragraph 5 of the order, the judge released Mr. Jones from his undertaking in damages. All of that in my submission shows that Mr. Cooper didn't have in contemplation that it could be anybody other than the fraudsters that were going to be affected by this order. I'll move on then next to my next section, which was service. Now, the respondent argues that the applicant, or the appellant I should say, shouldn't be treated as not having notice of proceedings because this was a consequence of Kyrrex choosing to keep Bitcoin in a custodial wallet. I say...
Can I just, I'm sorry to interrupt you, but before we leave this order of Mr. Cooper's,
yes, my lord.
Can I go back and try and understand precisely what it does? So paragraph 1 is summary judgment for deceit in a particular sum of Bitcoin, but that's against the first and second defendants.
Yes, my lord.
So we're not concerned with that. Judgment against the fourth defendant for holding the 89 Bitcoin as constructive trustee. Now, that must mean Mr. Jones's.
Correct, my lord.
But you say he doesn't. Huobi never held Mr. Jones's.
And that's now, save for a small amount, undisputed.
And then 2 seems to be recitals of fact, so presumably declarations. And then the second sentence requires D4 to deliver up to the claimant 89 Bitcoin, being that which was transferred out of Mr. Jones. Well, if Huobi doesn't have it, that doesn't require him to deliver anything, does it? I mean, if I'm accused of stealing your car and I'm ordered to deliver up your car and I don't have your car, I can't satisfy the order by delivering someone else's car. The order's to deliver up those Bitcoin.
Well, in my submission, the effect of the court, the court has determined that the Bitcoin in the wallet, there is Bitcoin in the wallet, that belongs to Mr. Jones, and Huobi needs to transfer that back. Now, Huobi is then faced with a difficult position, but in fact there is no Bitcoin of Mr. Jones in the wallet. So
Exactly.
But what else is it to do other than transfer an amount of Bitcoin from that wallet, effectively? Otherwise, it would be in breach of the order. It has to make an election.
If one stopped at paragraph 2, it's not obvious to me that it would be in breach of the order. If it simply said, this order requires us to restore money taken from Mr. Jones, and there isn't any, then there's nothing for it to do. Now, then the question is, does paragraph 3 add to that? There's an order for delivery up against the fourth defendant. Well, that seems to be the same. And an order that the sum of 89 Bitcoin be transferred from that particular wallet to the nominated wallet. And it may be that it's paragraph 3 which requires Huobi to transfer a sum. But it does say the sum of 89 Bitcoin.
But of course, my lord, all of this lack of clarity comes out of the fact that the order's made on a misconceived basis in the first place.
Just running with that a bit, in proceedings which, at least so far as Huobi are concerned, have been served on, the judge has purported to determine that the amount in that wallet is Mr. Jones.
Yes, my lord.
So I think an argument we're not complying because that is wrong wouldn't be straightforward if Huobi were bound by the terms of the judicial determination.
Well, that's my submission, my lord. The order's been made. Unless it chooses to try and set it aside, it's bound by it. The other point is that because it's fungible, it's not like being ordered to transfer something up where you need to transfer the thing in specie, in which case...
But that's what an order to deliver up, stroke restore, suggests. I mean, this seems to be a hybrid between a proprietary order, which says you've got my property, you have to give it back to me, and what is the sort of quasi-money order, which says you have to pay me X, but X is not expressed in currency, but in Bitcoin.
But of course, at the core of this, my lord, is Huobi choose to comply with that order.
Yeah.
My client, Kyrrex, is part of the class of persons that was...
Well, I understand that. The question is, what does this order require Huobi to do? And you say, echoing my lord's point, that although if it appeared to defend the action, it could have said there isn't any money transferred from Mr. Jones, because they haven't appeared. Yeah. The court's declared that 89 Bitcoin in the wallet was Mr. Jones's, and they have to pay that back, and effectively they can only comply with that by taking 89 out of the wallet.
Exactly.
The issue is not whether it's a very good order, but whether you're directly affected by it.
Yes, my lord.
You're in a situation, aren't you, where although the order is an order in specie, if an equivalent is handed over, there's unlikely to be any complaint of non-compliance. So it's unusual in that respect. If it was an order for delivery up of a sports car and someone handed over a different model, you would probably get a different response to handing over different Bitcoin to that which the order was specifically aimed at.
I mean, it's more like saying if it were cash.
Yeah, it's
Saying
sort of
cash.
yes,
It's not exactly. It's not the same notes. Well, no one would normally notice whether it was the same notes or not. That you're still transferring back the cash.
Yes, but if you steal my money, I don't get an order for delivery up, which is a proprietary order. I get a money judgment.
Well, that may be a different question, my lord, of course, of whether or not a delivery up order is appropriate in respect of cryptocurrency. Now, of course, you know, it's been defined now as property by this court.
But does the expression different Bitcoin beg a question?
In this particular context?
No, but I'm just generally, I'm just trying to follow the argument that, I mean, is there such a thing as different Bitcoin?
Well, yes, my lord, because each Bitcoin is a particular entry in the blockchain. So different Bitcoin is a different entry in the blockchain, but because Bitcoin's fungible, like cash, it doesn't really make any difference if it's not the same note.
Well, I mean, all right, I'll stop there. Where have we got to? Service.
Yes, so just to finish off on that, I just want to say the other point is, of course, one can see from Mr. Davison's report the exercise Huobi would have had to go to as a mere custodian to show that the order was wrong. And it's perfectly understandable that Huobi wouldn't do that. They would just interpret the order as binding them and comply with that.
And just remind me for my note, Huobi ceased to exist when?
October 2023. But as I understand, it's been succeeded by a company called HTX that now operates that exchange. Yes, my lord. So coming back to this point about service, what I say is that the court can't take arbitrary views or express qualitative judgments of who should be served and why. The requirement is for the court to have jurisdiction, proceedings have to be served. It's an absolute requirement because of the fundamental principle. Even those who deliberately evade service still have to be served by alternative means. And as Lord Sumption pointed out in Cameron, which we'll come on to look at a little bit later, the court's power to dispense with service is not really for situations where one thinks, oh, well, they don't deserve to be served. It's for situations where, in all practicality, the party knew about what was happening and just taking a technical point about it, it wasn't delivered on the right day.
So given the information that had been placed before it, what was the court's obligation in relation to service directions? What are you telling us?
So what I say is what the court understood, what Mr. Cooper understood he was doing, was that service on persons unknown in categories D2 and D3 would be the fraudsters themselves, because it was only them who had transferred Bitcoin into the T-Hell wallet.
Yes, but I'm just trying to. Are you saying the court should have made a different order for service than the order that it did make?
Had it known the true position, yes.
Yes, but that's easy. But in terms of the information that the court had, you're not suggesting it should have made an order for service on you or indeed any other individual.
I suppose, my lord, it depends what view the court took of the fact that before Judge Pelling, Mr. Jones had applied for a disclosure of information order as to who.
Yes, and that hadn't been complied with, and so nobody had that information. So I'm just finding it, and as you're embarking upon a fundamental principle, as you say, paragraph 7 of your new skeleton argument, I'm trying to see how it's engaged at all in this case, in which the court, as it seems to me, would have had no reason at all to say, tell Kyrrex at that point. But maybe there is a reason that you're about to point out that it should have spotted this of its own accord, whatever it was told by Mr. Jones.
Well, no, if it were told, my point is the court should have been told the proper position. Had it been told the proper position, then Kyrrex would have been served. So the order's made on a fundamental misapprehension. I don't say that's the fault of the court, that's the fault of the claimant. But I say it still means that the effect of it is that the fundamental principle has been breached. Because
why should Kyrrex have been served? Because, I mean, on your case, Kyrrex has nothing to do with Mr. Jones's Bitcoin, so why should it have been served?
Because an order was being made against a wallet in which it was a part of a class of persons who had Bitcoin.
Yes, but if the claimant had appreciated that none of the money in the wallet came from the claimant, it wouldn't have targeted that wallet at all. I mean, I find it difficult to see that it's a criticism that Kyrrex should have been served when on the claimant's case, Kyrrex had nothing to do with this. It wasn't Kyrrex's property at all, it was theirs.
I mean, does this feed in later when it comes to the position when Kyrrex does put its head above the parapet and its relevant context, do you say at that point?
It is, my lord. It also shows why Kyrrex is directly affected, because the order that is made on the basis that it didn't have any interest in the wallet. But it did have an interest in the wallet. Had the order not have been made on the wrong basis, then it would have been entitled to defend the claim, and it would have come to court and said, well, hold on a minute, no, none of Mr. Jones's Bitcoin ever reached the wallet, so you can't make an order against the
So it
wallet.
wouldn't just have been Kyrrex, it would have been other people as well.
But it's part of the class of person. And any one person who's affected by it has the right to come to court and say, well, I want to be a defendant to this action, my interests are affected. Could I take you then next to Mr. Cooper's judgment, please, my lord, which is at page 125. Starting on page 127. Paragraph 1. He says, the claimant also makes claims against the third defendant, but those claims are not material for today's purposes. Well, my lord already has the point. It doesn't appear, in fact, that the claimant did make any claims against the third defendant. He then goes on to say at paragraph 3 that service had been affected against the first to third defendants, whereas, as I've shown you, in fact, the first to third defendant, well, the third defendant wasn't served. D1, 2 and D4 were served, but the third defendant wasn't served. At paragraph 5, he says, final sentence, what follows by way of factual matrix is taken from the evidence of the claimant, including Ciro, who were the forensic investigator, which he says he accepts in absence of any contrary evidence. And of course I say that's what's at the nub of where all of this went wrong. At paragraphs 10 to 11, he deals with what Mr. Jones had done. So, as of 1st of May 2020, Mr. Jones has decided he's been defrauded. He instructs lawyers, but it takes him until 5th of April 2022 to get an expert report. Now, this will come to be relevant later because, of course, Kyrrex is criticised for the period of time it took to bring this application. And you'll perhaps note, my lords, that in fact it's pretty reflective of the time it took Mr. Jones to get his ducks in a row. And then paragraph 11 is the crucial paragraph which Judge Pearce comes on to describe as being wrong, in particular in the last sentence, where Mr. Maguire, who was Mr. Jones's counsel, had told the court that the Bitcoin held in the wallet can only be Bitcoin which has been transferred to the wallet by individuals connected with the fraud on the claimant. And Judge Pearce says that that was, of course, wrong.
But it accurately represented what the court had been told at the time.
Yes.
And what was the length of time that the expert report took?
So when we come to talk about the question...
Yes, I understand that, but you just said, you made the point,
Yes.
see how long it took them.
Yes.
And in terms of months and years, that was how long?
Well, just less than 2 years. So 1st of May 2020 and 5th of May 2022 was when the expert report was provided.
I'm just struggling with, as I understand it, Mr. Jones invested £480,000 initially in Bitcoin with various exchanges, producing an amount which, as at the date of that judgment, was worth 1.536 million. The wallet, is that figure right? Is that 345 million US dollars it contains? Because I struggle to see how all the money in that wallet could have been transferred by individuals. Does that mean it's individuals who've basically practiced a fraud on the claimant, but also on potentially other innocent individuals as well?
I believe the court was operating under that apprehension, and also that other fraudsters used the wallet.
Okay, so it's a sort of Fagan's den of cryptocurrency.
I mean, when we say what the court was told, of course, it depends to what extent the court scrutinised the expert report, Ciro. But when one looks at what Mr. Davison says, Mr. Davison says, well, the expert report CIRO was a slim basis on which to make any of these findings, because one can see just from looking at it that it hasn't traced any Bitcoin. In fact, it only even purports to trace 57 out of 86 Bitcoin. The remainder, it says, went to different exchanges which it didn't pursue at all. And what the expert said in there was he got to the point where he said, well, this wallet has been identified as a wallet that's used by fraudsters. So, therefore, it's fair game, essentially.
Do you have any explanation for the figures that appear in paragraphs 10 and 11? Paragraph 10 says, a wallet connected to this fraud, which I assume is the THEL wallet.
Yes, my lord.
Is said as at 1st of April to have 488 Bitcoin in it. And then the same wallet in paragraph 11, just a few months later, is said to have nearly 15,000 Bitcoin in it. Are those figures really comparable? What's happened?
Yes, I don't know, my lord. Turning then to paragraph 15, final sentence is said for fourth defendant, as against fourth defendant, the claimant submits that he had an equitable proprietary claim to the Bitcoin on the Huobi electronic trading platform. So Huobi's being targeted as essentially as the custodian of the wallet, not as itself the fraudster. And at paragraph 21, that's borne out. He says, satisfied the fourth defendant does sit.
I'm very sorry. I was just following the point that my lord made. We'd gone back to one of the interim orders, which has a recital at page 100, bottom of the page, about the value of the FEL wallet at the 23rd of June.
Are you looking for that order, my lord? Is that?
Well, I was looking at page 100 in the same bundle, bottom of the page, over into page 101 at the top of the following page, which gave a number of Bitcoin.
Yes, 9801.
9801, 166 million, and I'm just trying to coordinate that with what appeared at 128. With 20th of July 2022 and 23rd of June 2022. Just to try and understand what's actually going on
Yes.
with this wallet, if these figures are accurately.
Well, it's hard to say, my lord, because we
But no conclusions can be drawn.
no, my lord. At the time, Kyrrex understood that the wallet was its wallet and only it used the wallet. He subsequently, and Huobi said that to them at one stage in September 2022. This is dealt with in Mr. Plumpton's witness statement. Huobi says, well, we're transferring your Bitcoin because you control it's your Bitcoin that's in the wallet. I think that's paragraph 44 of that statement. In fact, it turns out that the wallet was used by lots of different people and there was more money in there, more Bitcoin in there than had ever belonged to Kyrrex. But Kyrrex wouldn't know that because all Kyrrex sees is its balance within the wallet. The wallet is used by the exchanges. They use the wallet however they choose to use them. So the position has never been very clear as what's actually in the wallet.
You can't tell that by looking at the publicly available information as to the ledger.
I'm being told you can tell if you go and look on the blockchain at the publicly available.
Let's suppose this is a mixture of an honest account and also a dumping ground for thieved value. I'm just trying to work out how you know which is yours and what the scale of the thing is and what the scale of your holding as you saw it. And because that might bear on it, might it not bear on whether on what happened next? And
well, I say not, no, because the inevitable in the order being made was that Huobi had to transfer, if it breached the order in my submission, certainly paragraph 3, or it transferred 89 Bitcoin from the wallet. The 89 Bitcoin belonging to Mr. James wasn't in the wallet, so it had to choose, it was an inevitable election, it had to choose someone's Bitcoin to transfer. And it happened to choose Kyrrex's, and it debited Kyrrex's account. And Judge Pearce accepted that.
Right.
So I say that's...
So it doesn't matter if it might have landed on somebody else, it landed on you.
I'd say there's two elements to which it matters. It matters in the sense of we were always part of the class of persons on who it might land. So that's one reason why we're directly affected. Second reason why we're directly affected is that in fact it was us on who it landed. And so there's two ways in which I say we've been directly affected. One is we should have been able to defend this because we were part of a class of persons. Two is enforcement of the order. My learned friend says, well, that makes for chain of causation. I say, no, it doesn't. It's an inevitable election that Huobi had to make. And to say that the unfortunate individual, who is the only person who's ever going to challenge it, because as Huobi have shown, they've no interest in challenging it. So the logical conclusion of my learned friend's point is that whoever is unfortunate enough to have their Bitcoin taken away by this order, because Huobi choose to enforce it in that way, has no right to come to court.
But because it could have been somebody else.
Yes.
And
Right.
that submission would be the same whether 90% of the Bitcoin in the wallet was yours or 1%.
Which is why I say in my submission it doesn't matter what's in the wallet.
Do we need to grapple with the nature of your interest in the Bitcoin in the wallet? Because we don't really have any information about your contractual dealings with Huobi. And there is a question, as I understand it, as to whether when you have a wallet of this type, Huobi obviously has, in some sense, a proprietary interest in all the Bitcoin in the wallet because it holds the private key and is able to deal with, and as your case shows, lock out the other interests in the Bitcoin. But what is the nature of your interest in the Bitcoin? Do you have a proprietary interest in it? Do you need to show a proprietary interest in it, or is it enough to show you've got a contractual interest?
In my submission, it's enough to show you've got a contractual interest. It's the same as money's in a bank account. Money's in a bank account you have no proprietary claim to. But if the bank were to deal with your money in a way that was not right, then you'd have a claim against the bank for using that money. Or a claim against the person whose order the bank was enforcing by taking your money out of the bank account. Whether or not there's a proprietary interest, which my only friend puts store in, I say doesn't make any difference.
Well, we're not in a position to determine that, are we?
No,
we simply don't have the requisite material.
Which is why I don't sort of give a position on it, because it's not my role to give evidence. But
It is an oddity that we do not have from your clients the terms and conditions on which you're able to operate this account. Now, as it happens, they are quoted from in academic commentary by people who got them off the internet. But we have no idea what they are.
No, and of course I'm stuck with the
We are where we
facts
are.
as they were there. But as I say, in my submission, it doesn't make any difference. The question is, are you directly affected by an order? But if I've got a shows in action over monies in an account,
So whether you had a proprietary interest, a beneficial interest, a contractual interest, in the end it was yours and you don't have it any longer.
I have a right recognisable at law.
Yeah, I just wonder if the bank account analogy works there, really. I mean, if I had a personal claim against the defendant who doesn't have enough money to meet all the claims against them, and I want to set aside a judgment that someone else got against them for a big sum of money on the basis that it's reduced the pool pari passu for everyone else. For my part, I would be rather surprised if I could meet the standing test to set aside the default judgment on that ground alone. So
Yes.
I'm just struggling where if we don't have a proprietary claim, what it is about this case that keeps us on the right side of that problem.
It's for distinct. I mean, a bank, in my understanding, a bank wouldn't operate an account like a custodial wallet. So what you have here is a strange position where someone's Bitcoin is in a pooled. It would be like having a pooled bank account with other customers of the bank.
Well, that does happen with solicitors' clients' accounts. Because solicitors have their own money, but they hold an enormous amount of client money, and they tend to operate one or more bank accounts, which is pooled with all their clients. And each client has an interest in the account in the sense that all the money is trust money and it's held for all the clients. If there was an order against the solicitors, which they satisfied by taking a sum of money out of that pooled account, then it would be a similar sort of position to what we have here, as I understand it.
And the position would be the same in my submission, which is all the bank is doing in that scenario is acting in a ministerial capacity to apply the order. And so you still have a claim, still entitled to set aside the order, because all they're doing is implementing the order with an inevitable election, and the election comes about from the flawed basis of the order. There's no answer to say, oh, well, Huobi chose to do this. Well, they had to do it because an order had been made, unless they applied to set it aside.
You say they had to do it. They played no part in the proceedings. They didn't comply with the the orders of the court, and they still had to do it. You say?
Well, under the order of the court, they had to, yes.
But if they'd been acting responsibly, they would have they would have gone back and got the order changed, if there was a basis for doing so.
And one might say if the claimant wanted to pursue the matter, it needed to pursue the provision of information, not apply for information, not get it, and then carry on as if they'd had the information they asked for. Why ask for the information if it wasn't necessary in order to get the order? But having not got it, they just carried on anyway and said, well, we still have an order, please, against whoever does own the wallet or the Bitcoin.
Well,
wallet.
no, I think that's probably. I mean, they didn't need to know who claimed to have interests in the wallet. All they needed to establish was that 89 of the Bitcoin in the wallet had come from Mr. Jones, and that's what they thought their expert evidence did establish. Once they've established that, then the order that Mr. Cooper made is a perfectly sensible and satisfactory order, isn't it?
But of course, that evidence was flawed.
Yes, but you said, having asked for the information from Huobi, they shouldn't have gone ahead without getting the information. But what if they can satisfactorily demonstrate, without knowing who it is, that somebody has got hold of their 89 Bitcoin and it's in this particular wallet? All they need to do is say to Huobi, 89 of the Bitcoin in that wallet belongs to me, give it back to me. And that's exactly what they asked Mr. Cooper to do, and that's what Mr. Cooper did. And that ought to have been enough. If the evidence, if the Ciro evidence had been accurate, that perfectly satisfied. There's nothing wrong with it, is there?
Well, my lord's point was, well, Huobi didn't engage, and
Yes.
therefore...
But Huobi doesn't need to engage. All it does is pay over the money.
Well,
which it's
exactly,
done.
therefore affecting my client's interests.
Yes. So your complaint, and this is one of the points taken against you, your complaint is that Huobi, having paid over the money, then chose to debit your bit of the wallet, whereas there were lots of other people. So that was a choice by Huobi.
But it was an inevitable...
Well, it's inevitable they would have to
Exactly.
take it from somebody. It wasn't inevitable they would have to take it from you.
But to say that that means that the party who they do choose can't apply to set aside the order, in my
Well, that's the question. That's the question.
Did they ever explain why they took it from you, Deb, and not anyone else?
They don't, but the correspondence in September indicates that at that stage they thought, for whatever reason, they probably operate lots of wallets, and so they hadn't really appreciated. They seem to think it was a Kyrrex wallet.
Can you not now, but at some point, perhaps dig out the reference for that? That'd be great.
It's later in my notes, which
Thank you very much.
I should probably return to if we're going to get through it. I'll then just give you some, try and do it quickly because I've got one eye on the time, the parts of Judge Pearce's judgment, so the undisputed facts for the purpose of the set-aside application. At paragraph 7, Judge Pearce's judgment. It's in the core bundle, page 76, tab 9. So paragraph 7 is where he says that the judgment was wrong to attribute any cryptocurrency having arrived in the T-Hell wallet. That's the second line. And then a point about paragraph 11 being wrong, to say that it could only have been transferred there by the fraudsters. Paragraph 9, he says the order identified in the event wrongly 89 Bitcoin to have been transferred to the THL wallet. Paragraph 17 says, and this is where he makes a finding as to what's happened in relation to it being Kyrrex, that's the party that's paid. Kyrrex has had Bitcoin moved from its name effectively to ensure that Huobi has not suffered in satisfying Mr. Jones's loss. At 18, he says, the case brought by Kyrrex starts by asserting, as is now entirely accepted, that Mr. Jones's case wrongly identified his Bitcoin as having been paid into the wallet. 19, he says, second line, Huobi transferred Bitcoin from a different wallet, but then looked to Kyrrex's account in the TL wallet to reimburse it. 23, he talks about how Huobi controlled the wallet, and to the point raised earlier, Huobi was able to identify in a way that did not allow the public looking at the blockchain to identify what was in the wallet and who claimed ownership of it. At paragraph 32, he says he accepts that the original order was made on misleading information, both as to whether the stolen Bitcoin had been paid into the account and as to whether it was exclusively, the Bitcoin in the account was exclusively the subject of fraudulent credits or transfers into it. He says this may have influenced the order that Mr. Cooper made, and it's probable that he actually was misled. And at 35, he says Kyrrex undoubtedly had Bitcoin to its credit in the THL account, and Huobi's action, having satisfied the order in favour of Mr. Jones, was to transfer assets from the Kyrrex account back to replenish its own accounts, although Mr. Jones doesn't necessarily accept that matter to be made out, but he agreed with Mr. Laurel that the evidence on that issue pointed in all one way, which it did. My Lords, the report relied upon by Mr. Jones to obtain the interim final relief was massively flawed in my submission. And that appears from the report of Mr. Davison, which is at page 82 onwards.
Where are we in your list of 10 points at the moment?
Yes, we're... we're on 5.
Right, we're still with the undisputed facts.
Yes, we're on.
Thank you. Sorry. What was the point?
Just to look at Mr. Davison's report at page 146, I think, onwards of the supplemental bundle. Slightly
we don't have a Cyril report, do we?
No, my lord, we don't, I'm afraid. We do have Mr. Davison's 82-page analysis of that report, which in the end Ciro didn't respond to. The Prometheus report, which was obtained by Mr. Cooper for the purposes of the application, focused on a different question, which was whether or not it could be shown that it was actually Kyrrex's Bitcoin that had been transferred back, which, as you know, I say, that it doesn't matter. It was debited to its account, and that's what matters. And so one can see from the report various issues with the evidence.
Sorry, just on that point.
Yes.
Para 35 of His Honour Judge Pearce's judgment appears to accept that the effect of setting aside the order would be a recrediting of Kyrrex's account. Have I understood that correctly?
Paragraph 35.
35, yeah.
Yes, my lord, I think so.
Which may not be without significance.
Yes, as I say, undisputed fact is that it was Kyrrex who was debited for the purpose of the transfer.
Because, you know, if in my creditor example, the effect of setting aside the default judgment would simply be to increase the asset pool of the judgment debtor. Whereas here, Judge Pearce appears to have accepted the effect of setting aside would be to increase a credit for your client in the
I'm sorry, I'm being very stupid. I don't see that in paragraph 35.
I took my lord to be referring to the fact that it says the order was satisfied.
Maybe I misunderstood the paragraph.
Sorry.
So the first line, the order was satisfied by Huobi transferring Bitcoin. Kyrrex undoubtedly had that in its account. Huobi's action having satisfied was to transfer it to replenish its own account.
Yes, it's a different point, I think.
Yeah, no, apologies.
Yes. Right, we were back with.
Yes, I'm conscious I'm short of time, and we rely on the judgment essentially, but if the court has the chance to look at the expert report, I'll just run through quickly some of the points that come out of it. At page 146, Mr. Davison says there was little substance to the report relating to the tracing of Mr. Jones's stolen Bitcoin. It actually had been sent from his Coinbase account to a number of different exchanges. There was no particular reason to focus just on Huobi, other than that it looked like it was good for the money. He says there's no evidence to link the stolen Bitcoin to a T-Hell.
So this is in the middle of.
Page 146.
Yeah.
I'm sorry, my lord, I'm speeding up because I've still got quite a bit to get through.
Right, well, why do we need to go through this in any detail if you're going to throw stuff overboard to keep in time?
Yes. Yes.
There's an expert report which is now still standing, which that third paragraph on page 146 is the essential point, is it?
Amongst others, you can
Are
see...
there any other essential points? Which ones do you want?
Well, page 148 is another key point, which is that 57 of the Bitcoin, the 80 odd Bitcoin, 57 of them weren't traced at all by Mr. Jones's expert because they went into different exchanges.
Second paragraph on 148.
Yes, my lord. I'll turn to areas of remaining disagreement then.
Thank you.
So first of all, paragraph 4, my learned friend's supplemental skeleton said they don't admit that the judgment against whoever cannot be sustained. Well, in my submission, I've shown you what the basis of the claim was, shown you where we've ended up at with the findings and the expert evidence. The claim is put cannot be sustained. Mr. Jones would need to go back to the drawing board. It's next said that Huobi, paragraphs 5 to 6, Huobi didn't act in a ministerial capacity. I believe I've already answered this point. My submission is that they did, because they had to do something pursuant to the order. It knew it wasn't the fraudster itself, so it wasn't going to transfer its own cryptocurrency. It was going to transfer cryptocurrency that it believed must be the subject of the order. It said at paragraph 11 that Kyrrex's position in terms of service is analogous to a principal who's expressly or impliedly appointed an agent to accept service. I say you can't reason by analogy as to whether someone's an agent or not. They either are or they aren't. That's a question of fact. It wasn't advanced below. It said that Kyrrex has failed to show proprietary right to the Bitcoin in T-Hell wallet. I've already answered that point, my lord. We don't need a proprietary claim in my submission. So turning then to the test under Rule 40, under CPR 40.9, and I've addressed this in my skeleton argument, supplemental skeleton argument, paragraph 9 onwards. Well, there's little guidance or authority on the point, but the purpose in my submission of the rule and its purview is obvious. Persons directly affected by an order should be entitled to come and set it aside, or vary it, and it's to ensure they've had the opportunity to be heard. It's back to that fundamental principle. Person unknown cases are an area where it's likely to be particularly relevant. Types of cases, these types of cases, I should say, persons unknown cases, were first considered by the Supreme Court in Cameron and Victoria Insurance, where at paragraph 12, Lord Sumption, and I'm sure it's a case Lordships are familiar with, Lord Sumption identified the critical question when looking at these matters is, what's the basis of the jurisdiction of a court over parties? And it must be service. If they've not been served, the court doesn't have jurisdiction over them. And he identifies that at paragraph 14, saying at paragraph 15 that those who are identifiable but anonymous can be served, if necessary by alternative means. And at 17 and 18, he then identifies the problem with proceeding against a person who can't be served, stating the fundamental principle that we've referred to. A person cannot be made subject to court jurisdiction without the opportunity to be heard. So whether or not it was legitimate for the court on the evidence before it to conclude that Kyrrex didn't need to be served, the point is, in fact, it did have an interest on the true facts, and the court, to have jurisdiction over it, there needed to be service. And at 26 is where he says dispensing the service is not an answer if the party hasn't effectively been served. So I say...
Sorry, I'm sure I'm being slow here, but you're referring here to your fundamental principle at paragraph 7. A person cannot be subject to the jurisdiction of the court without notice. In what way was your client subject to the jurisdiction of the court?
Because the order that was made was over a wallet in which it had cryptocurrency. It was made on the basis that actually only what cryptocurrency belonging to the fraudsters was in
That would apply. I mean, let's suppose a big judgment was given against a small business, which had adverse effects on other employees of the business, clients of the business, whatever it might happen to be. Why would they not be persons who are being made subject to the jurisdiction of the court? I mean, isn't this an argument which begs the question?
No, in my submission, not, because in that situation, it's the business that's the party that represents, and those people, their interest is with the company. Here, we are part of the class of persons that is directly affected because we own the assets in the wallet, and it's the wallet that's been... So, as I've shown you from the orders, all the orders are on the basis that the wallet belongs to D1 and D2, the fraudsters, as assets belonging to fraudsters. The true position is it contains assets, including our assets. So we're a person that could always have been a defendant to this if we'd have known about it. We didn't know that.
Just picking that point up, let's imagine we're pre-judgment. The court occasionally gets applications for people to intervene.
Yes.
And I'm wondering if there is any connection between the sort of person you would allow to intervene and the sort of person who would be directly affected.
In my submission there is, and you can see that from the protester cases, because usually the protester cases are return date of the injunction, and someone comes along who wouldn't otherwise necessarily be served, and they say, well, I've got an interest and I want to represent that interest, and then the court looks at, well, have you got an interest that would enable you? And you see from the cases I've cited in the skeleton, the Abdul Mahmood case, at paragraph 15 and 16 in the Court of Appeal and then in the High Court. The question is, would they be in a position to defend the claim or put forward a defence? Well, Kyrrex would have been. Kyrrex had known about this. Kyrrex could have come along and said, well, hold on, we want to defend the claim against the T-Hell wallet because actually that contains our assets, and so we want to defend it. And the court would have said, okay, well, you must be interested and you'll be joined as a party. It's different. If I came in and said, oh, well, I'm interested in this company because I'm an employee, the court would say, no, you can't be joined as a party.
Is that because it's a proprietary claim? Or I mean, would it be the same if it was a money?
The question is whether you've got a right or interest that entitles you to appear before the court, in my submission. May not be a proprietary claim.
On a slightly different point, your application was to set aside the judgment. With what consequence?
So I have a draft order, my lord, which should have reached you with the...
I'm sure it has, but in short order, what is the consequence of that?
So what we ask is that the money is transferred back, the Bitcoin is transferred back to Kyrrex.
Well, what happens if, that's a happy outcome from your point of view, but...
That assumes that you're right, but it's your money, but that question's not been tried.
Yes, that's my point, that isn't, I mean, if you have an arguable claim that this was all very unfair, then we don't know who the other people who were in that wallet were. We don't know we don't know what's going to happen to your business. I mean, you might take the Bitcoin and then go up in smoke. So what's fair about that? I mean, surely, if it was unfair that this order was made in the first place, then setting aside the judgment is pregnant with all sorts of possibilities for unfairness to other people, including to the original claimant in this case.
Well, the evidence below, and the court accepted, was that it was Kyrrex has been debited with this transaction. The basis on which it was debited was that Mr. Jones's Bitcoin was in the T-Hill wallet, which the judge below has now accepted was wrong. So the substrata of the judgment is wrong, and therefore in my submission, what should happen is the position should be restored to what it would have been but for the...
But what I'm really asking is there an intermediate position whereby the money can be preserved? I mean, well, if one can do such a thing to...
Yes, the alternative, my lord, is that it's preserved and it's remitted to the judge to look at that. Why I say the right order is simply that it's transferred back is that the claimant is yet to identify any basis on which it's entitled to this money. It said it was entitled to it because it had traced it to the wallet. That's been shown not to be correct. It hasn't put forward any reason why it's entitled to that Bitcoin in light of that. And the onus is on the claimant to do that. And having not done it, this is not one of those cases where we're saying, oh, we've got an arguable case. We're saying, actually, we've got an unanswerable case. The order was made on a wrong basis, and everyone accepts it was made on a wrong basis, including the judge below. So it must be set aside. If the claimant wants to bring a further claim against somebody, that's for the claimant. But bearing in mind it's alleging fraud, it needs an evidential basis to do it.
Leave aside this case, just looking at the structure of 40.9, the claimant has got a judgment. You say we should have been parties, or we should, if we'd known about it, we would have applied to intervene and defend the action. And if the court accedes to that, the judgment's set aside, at any rate as against you. And then what one would normally envisage is that you then come in and defend. You plead a defence, and then there's a trial. And it's only once you get to the end of a trial that it is determined who is actually entitled to this money. And you're trying to short-circuit that and say, well, we say it's ours, and they haven't said it isn't. And that doesn't really seem, I mean, that seems like you're applying for sort of summary judgment, in effect.
Well, I don't accept that, my lord, because what I say is the judge below accepted that the order, effectively the order should never have been made. It was made on a wrong basis. So what I'm asking for is you return the position to what it should have been, which is no order should have been made. And if the claimant has a claim to bring, it brings it. But we don't need to establish a defence. Our defence is already accepted. But that money in that wallet is not Mr. James's.
But let's say you don't have a proprietary claim, or we're not in a position to determine today, on the rather limited information available, that you do. Let's say you had a personal claim against Huobi, but you've got an arguable basis to, sufficiently arguable claim to set aside the judgment. Why would it be appropriate to order the transfer of what the law now recognises as property to you on that hypothesis?
Well, in my submission, because that was the evidence that was accepted below, was that the transfer was debited to Kyrrex. So whether or not we've got a proprietary...
There's no finding below that you had a proprietary interest in this.
No.
But also, it's a bit of a stretch to refer to things as being findings in a case where there hasn't been a trial. I mean, of course, the judge acted on reasoned assessments of the evidence, but this was an interlocutory application. They're not findings of fact in that sense. I think that's what underlies my my question to you, is as to whether there is a third way, which plainly there is, because the judgment could, for example, if you got to that point, be set aside on terms, I presume.
Yes, and it gets remitted essentially to the judge, my lord, to look at the matter further. And my submission is as simple as, well, why are we doing that when no one's really saying that this was actually Mr. James's? When it's accepted, it was transferred, debited to Kyrrex, I should say. Mr. James' claim to it is no longer established because his expert evidence didn't show that it was ever in the wallet. What is the case that we're defending? And the claimant hasn't said. It just said, oh, well, we don't concede that. It's too expensive for us to go away and get an expert report. So effectively, we'll see what happens on the appeal, I suppose, is what they say. I say they need to do rather more than that in my submission, but I accept the alternative.
I'm speaking, as it were, structurally, not to do with the merit of the
Yes.
particular argument. And I understand your position on that. All right. So you were trying to help us on the test under 40.9.
Yes. So I've taken you to Cameron. I was looking at Abdul Mahmoud and Egyptian Association in 15 and 16 of my supplemental skeleton.
Yes.
And I say, just taking a step back for a minute, what's meant by directly affected in these sort of cases? And in my submission, it's there to ensure that applications are made by the party actually affected, not, for example, a creditor, director or employee, but someone like Kyrrex would be affected. Given the importance of a fundamental principle, it shouldn't be a tightly construed definition of directly affected. And I say the situation is analogous to protesters. Even though there's differences between the protester cases and these, the position is analogous because what's key in the protester cases is that you're looking at people who may not find out about the order. You're looking at persons unknown who may not have an opportunity to be heard. And in that situation, the important bit about the low threshold, the generous approach, which is talked about in the Shell case, and the case is referred to there, is that it's persons unknown. It's not specifically that it's protesters. Now, Judge Pearce, in his judgment, took the view that, I deal with this at paragraph 9 onwards of a supplemental skeleton. He said at paragraph 28 that Mrs. Justice Hill's conclusions at 63 to 65 of Shell, which I invite the court to look at, were limited to the context of protester cases, and not necessarily these before. Now, first of all, Mrs. Justice Hill doesn't say that. She says they're in the context of persons unknown cases. Secondly, as I say, when one looks at what is said to be the reason for the broad approach, which is the draconian nature and the potentially broad effect of the order, those things apply to cryptocurrency person unknown cases just as much as they apply to protester cases. And the fact that one is human rights and another is potentially financial interests doesn't make any difference to that. There's no distinction drawn in 40.9 between the type of rights or in any of the authorities. The question is whether their rights might be affected. And even Shell doesn't say it's about the type of rights. It's all to do with the fact that it's persons unknown. I should draw your attention to the fact that, as at paragraph 13, now Mrs. Justice Hill in fact said it isn't, she didn't think, she doubted whether it was a discretionary test. We accept that there must be an element of discretion because it's such a broad rule of broad application that could apply to any kind of circumstances. The court, in applying such a rule, must have an element of discretion, I would say.
It's an evaluative exercise.
Yes, and which is, to be fair to Judge Pearce, how he put it as well. He said it's a question of judgment or discretion. And so I would accept that, but what I say is it's a narrow discretion because, in principle, the reason why 40.9 is there is that the court acts in personam, and when people are affected by a judgment, the court shouldn't hesitate to set the judgment aside so that those parties can have their day in court and have the opportunity to be heard.
So the argument goes that if you got to hear about this before the judgment, you'd inevitably have been allowed to intervene. If you'd shown up very promptly after the judgment, you would inevitably have succeeded, as you put it, in the judgment being set aside so that you could be heard.
Save that, if I'd have turned up very promptly, I probably wouldn't have had the evidence to persuade Your Lordship that the order was made wrong.
No, but I mean, this is in a world in which none of these practical problems arise. That had you turned up showing that actually this wallet of mine, which I had my Bitcoin, had nothing whatever to do with Mr. Jones. If you turned up straight away on that, your case runs that you would have succeeded, and the issue of whether there should be a judgment of that kind would have been decided after argument in which you were heard.
Yes.
Right. So that's how far your argument has taken you so far. And then the question is, what happens when you turn up some years later?
Yes. I'll just finish on 2 points before I move on to that, my lord. I
Of course.
appreciate the intervention. Yes, I say the other way to test it is, had Mr. Cooper have appreciated that in fact the fraudsters didn't control the wallet, or it wasn't all.
There wouldn't have been a judgment.
He would, or at least he would have said, well, you need to find out who does and they need to be served.
Yeah. Well, there wouldn't have been that judgment, is what you said earlier on.
Because he wouldn't have been satisfied persons unknown captured the true persons unknown. The other thing is, I just wanted to briefly mention, when we're looking at the question of indirect and direct effect, when any friend says, well, you only indirectly affect.
Are you under point 8 here? Direct effect.
Yeah, I haven't numbered them as I go through.
Yes, all right.
Forgive me, yes, I'm on 8.
Yeah.
Direct and indirect. Look at the investment trust code and revenue and customs case. It's an unjust enrichment case, Lord Reed in particular. And he there is considering the question of whether enrichment at someone else's expense, whether that can be direct or indirect. Which I say is informative here, because effectively the context is the same. Someone as it stands is unjustly enriched by an order. And I say that's on a technical as well as a non-technical basis. The Lord's looking at me.
Well, I wonder whether the answer to the interpretation of the civil procedure rule is really to be found in the Supreme Court's treatment of interceptive enrichment.
Well, the point put shortly is this, that he says, well, what one needs to look at is if something is all part and parcel of one transaction, then it's unrealistic to say it's indirect rather than direct, because in fact it's all one transaction. And the bank financier case is important on the facts of this case. It's in bank financier, which he mentions at paragraph 61 to 66 in the investment trust case. Lord Steyn there says, well, I'm not impressed by the point that it came from a different account, because it's all part and parcel of the same transaction.
I mean, it's not quite the same, but in Lipkin Gorman, the argument that you didn't spend the money you stole from the firm, you spent the chips you bought with that money, got fairly short shrift on the basis that they were just mechanics for how you gamble.
Yes, but it's a point I just wanted to deal with briefly. I'll move on to whether or not Kyrrex was directly affected. I've addressed you on that essentially. I'm under 2 infelicities. I say they're infelicities. So the fact it was Huobi that made a decision, and the fact that it came from a different wallet, it doesn't change what's happened here in substance. So looking at discretion, I've really made the point on merits. The order shouldn't have been made. It was made on the wrong basis. So that's all we would need to show to set the order aside. How far that takes me is a matter on which the court may disagree with my proposed solution. But certainly the order should be set aside. And likewise, that meant, and on the evidence before the court, Mr. Jones has no claim against Kyrrex. Kyrrex would also have had a counterclaim against Mr. Jones for restitution, but it would need to set the order aside in my submission to succeed in that, or even under the undertaking, the cross-undertaking and damages, because it's had its assets affected by reason of the enforcement of the order, which was obtained on the wrong basis.
How does that work? Because the cross-undertaking and damages was for the effect of the interlocutory injunctions, and you weren't affected by the interlocutory injunctions in any way.
Well, ultimately, in my submission, we were, in the sense of the summary judgment is enforcement of the...
Summary judgment's not enforcement of the interlocutory injunctions. The summary judgment is a judgment. And you say you were affected by the judgment, but I don't understand how you can claim on the cross-undertaking and damages, which is given as the price for obtaining an interlocutory injunction, which didn't affect you.
Well, it froze the assets that ultimately...
It froze the assets, but you're not complaining. I couldn't spend my assets during the time while the injunction was in place. No. You're complaining that my assets were taken away when judgment was given. It's got nothing to do with the interlocutory injunction at all, has it?
Very well. Could I look at the question then of promptness, which has been taken? I want to begin by looking at what Mr. Jones did, and I've already trailed this to some extent, but if we look at the judgment, well, I'll take it back to the references in Mr. Cooper's judgment. He closed his account in early 2020, that's paragraph 9, instructed lawyers and investigators on the 1st of May 20, paragraph 10, expert report 5th of April 2022, paragraph 10, supplemental bundle, page 4, shows the claim form was issued on the 1st of June 2022. So consequently, more than 2 years to bring the claim and the applications for interim relief. And by comparison, my lord, there was about 20 months between Kyrrex obtaining disclosure and issuing its application. In my submission, Kyrrex had the bigger task, because you can see from Mr. Davison's report the extent of what was involved to show that the rather superficial report of zero in my submission was wrong. And that would have taken, on any view in my submission, weeks of work. So in my submission, one's looking at a comparable period that it's taken each party to get their ducks in a row, and that should be borne in mind. Because when we're talking about direct effect, we have to bear in mind that the judgment itself was indirect, in that it affected assets that didn't belong to Mr. Jones. So we're also looking at an indirect effect coming back. The two mirror in my submission. Then looking at the question of prejudice to Mr. Jones, in my submission, the cause of any prejudice to Mr. Jones is his misconceived expert evidence. That was pointed out to Mr. Jones by Kyrrex as soon as it became aware of the order in September 2022. And the relevant correspondence is in the supplemental bundle from page 282 to page 293. And including in that was Kyrrex saying, well, our account didn't even open until 2021, I think it was, and your fraud was completed by 2020, so how could it possibly be your money? It's a pretty strong case put forward straight away, which Mr. Jones could have engaged with. The judge also relied on the fact that Mr. Jones has a claim against Huobi, but at least on the basis of his evidence put forward so far, he doesn't. So the fact that he could no longer pursue Huobi is not prejudicial. He's not established he's got any claim against Huobi.
You've mentioned the correspondence.
Yes.
I haven't looked at that. 282 to 293 on this point.
Supplemental bundle, yes. I mean, it's quite lengthy correspondence, my lord, so...
So the essence of the matter here is that on the face of it, Kyrrex very fully set out its position at the outset, but then didn't do anything forensically significant about it. For when was the application then issued?
Well, so we first of all had to get disclosure from Mr. Jones.
Yes, no, but just as a matter of dates. So
yes, so
there can't be any complaint that you didn't vigorously complain and explain why you were vigorously complaining as soon as you were made aware.
Correct.
But the
application was made.
The length of time before the application was made.
The application was 27th of November 2024.
So 2+ years.
Yes, my lord. But we say, and the judge accepted, that until 15th of March 2023, we didn't have the necessary disclosure from the respondent.
So if we're calling it delay, I appreciate you've got some arguments about this, but if we're calling it delay, it's in the nature of 1.5 years.
Yes, my lord. Well, except that it would, as the judge also accepted, it would take several months to produce an expert report.
Yeah.
And in fact, it took from the 13th of March 2024 to October 2024 for our expert report to be finalised. So what's that? That's about 6 months.
So it took a year to instruct the expert.
Yes,
and then half a year to get the report.
And if you consider Huobi's striking off to be significant, that took place in October 2023. So we say within the period, and we say the judge failed to appreciate this, within the period where we would still reasonably be getting our expert report together. So it's within 7 months of us having the disclosure.
What's the significance of that? That there wasn't a source of information from that direction? Is that it?
What's the significance of a lack of disclosure?
No, the significance of Huobi having evaporated.
Well, I say there's no significance to it because the claimant.
No, but I was wondering whether you were saying it was made more difficult for you to get your case together.
No, my lord, no,
that
sorry.
wasn't the point. No,
I'm answering the point that the judge made that it was prejudicial. Our delay was prejudicial to the claimant because Huobi was struck off.
You're saying even if 15th of March 2023 ploughed on, get expert report, a reasonable timescale would still have led to this application being brought after Huobi had gone under.
Added to which, add on the 2 years it took Mr. Jones to bring his claim in the first place, that has put him closer to the October 2023 date. You can't, all of that, the consequence of when Huobi was struck off, which was outside anyone's control, and shouldn't be entirely visited on Kyrrex, seemingly because it's being said it should have produced its expert report a little bit quicker.
Well, was there any evidence as to why it took a year between getting the disclosure and instructing the expert?
The evidence is within Mr. Plumpton's third witness statement. In a nutshell, what he says is these matters are not straightforward. We were looking at the possibility of pursuing the action, whether we should pursue Huobi, what we should do. Decisions have to be taken internally. This is complicated litigation, all those kind of things, which I say is fair enough. And when we come to look at the Lombard case, this is complicated litigation. It's not like getting a judgment against your car or something about a finance company and you know you can immediately go and set it aside. Someone here has produced an expert report seeming to show that you're implicated in fraud. One needs to get one's ducks in a row before one can go to court and say, well, no, we're not.
Well, I understand that, and you say it was perfectly reasonable to take 6 months to get your expert's report. But that doesn't explain the length of time between getting the information, realising what the problem is, and getting the expert to say. Anyway, can I go back to a point you see? I understood you to say that the supplementary bundle at 282 to 293 was you telling Mr. Jones straight away that he was wrong.
Yeah.
But it's not obvious to me from those letters whether they're written to Mr. Jones or whether they're written to Huobi.
They're written to Huobi, but if you look at 288,
yes,
that's sending it a letter on to HCR where Mr. Jones's representative.
I see. Okay, thank you.
Sorry if that wasn't clear.
So what is sent to Mr. Jones's S. Murray at HCR Law, Mr. Jones's solicitor?
Yes.
And what is sent is the letter of 22nd of September, and that's the one. Well, which one is it? I mean, well, no, maybe it's the 19th of. It's the 19th of September.
Yes,
so it's 2022 September 19th, which is an odd way of putting it, but it's the one at page 283.
I'm sorry if this takes us away from this, but could you just point us to the data which passed between you and Huobi, in which Huobi said we're taking these from your account? Could we just have the reference for that, please?
It's in, I believe it's in Mr. Plumpton's third witness statement. Oh no, I think the second actually. Just bear with me. Please, my lord. Yes, so my lord, if one looks at, and you don't have the exhibit, I'm afraid, but if you go to page 32 of the supplemental bundle, and you then follow it through from paragraph 33 to 45, Mr. Plumpton describes the interactions with Huobi.
So who is speaking here?
Mr. Plumpton, he's a representative of Kyrrex, I believe the CEO. And paragraph 44 was the one I mentioned a couple of times. 30th of September, where Huobi say, That's page 36. A tea hell wallet is associated exclusively with Kyrrex.
Sorry, I'm just reading this as well.
Yes.
33 through to
Sorry, my lord.
33 through to
45, my
lord.
lord. Oh, it's paragraph 33 to 45.
To 45, thank you. Just give us a moment.
Just go back to the question
No,
of...
So we'll just look at this
Yes, my
first. Thank you.
Well, going back to the question of prejudice and Huobi being struck off, I say it's important to bear in mind an alternative claim would involve tracing the Bitcoin in the way that Mr. J purported to do in the first place. And Huobi being struck off makes no difference to that because one would still trace through the blockchain. Added to which, as Mr. Davison's evidence shows, there were numerous other exchanges. 57 of the Bitcoin was either traced or not traced, whichever way around it was, I can't recall now, but a significant proportion of the Bitcoin went through other exchanges, so nothing to do with Huobi. Likewise, the suggested prejudice that Mr. Jones is a long way behind any other fraudsters. Well, he was along in blockchain tracing terms. When he issued his claim, he was a disproportionately long way behind following fraudsters who'd moved the money. So if they weren't in that particular wallet at that time, 2 years later, bearing in mind blockchain transactions, millions a day can happen. He was already a long way behind. If he's further behind, that's due to the error in his evidence that he obtained. It's not due to what we've done. And he knew what our position was in September 2022, and if he wanted to take action accordingly, he could have done that.
I mean, it seems to, speak for myself, that arguing about the exact amount of the delay and whether it tips the balances is not likely to be very profitable because it's an evaluation. But we're looking here, aren't we, at 48 through to 52 of the judgment page, for 87 of the core bundle. And if I've reminded myself of it correctly, effectively it's paragraph 52, which is that the judge is relying heavily on the substantive issues, which we've been hearing about and will continue to hear about, as being the important reason for refusing to exercise the discretion. It isn't just an evaluation of delay, not a case in which, for example, you have a perfectly arguable case, but you've waited for so many years that it's too bad. He was relying at least significantly, if not decisively, on a rejection of the merits of your position. How do you read it?
I wouldn't read it quite like that, my lord, because he does say at the end it would in any event have failed on the application of merits test, bearing in mind not only the merits of the claim but also the delay in bringing this application and the consequent prejudice. I accept what you say, my lord. It's an evaluative question, and what I say is he got the evaluative question wrong in a way that this court can revisit it, because it was wrong in...
Yes, but even if taken in isolation, the judge's assessment of the issue of delay was a perfectly reasonable one against what you're saying. I mean, this was at least a three-legged stool, and it needs all the legs to stand up. is one way of looking at it.
Well, he did find the delay wasn't gross.
Yes, but he said on the other hand, this is what you've just been dealing with. He said it had caused prejudice because
And I say that's
Huobi'd gone.
and I say that's wrong. It hadn't caused any prejudice. What had caused prejudice was the claimant getting his case wrong in the first place.
Yes, but the striking part of the analysis is that this was, in his view, a classic example of an indirect effect. And so, in a sense, if you go down on that, the rest is not much help to you. Whereas if you're right about that, then that would seem to disturb quite fundamentally the judge's assessment of the discretion.
Yes, I see the point you make, my lord.
I mean, that's really one way of looking at it.
Yes, my lord, and it must be right. I mean, if we don't get over the direct effect hurdle, the discretion is not relevant.
No.
I accept that. I say we do get over the direct effect hurdle. I say then he gets the merits analysis wrong because we were just entitled to have the order set aside because the basis on which the order was made was wrong. There was no evidential basis for it. Well, there was an evidential basis for it, but it was wrong. So it must be set aside. He engages in an analysis of whether we've got a proprietary claim or an unjust enrichment claim, which I say is immaterial for the purpose of getting it set aside at least. We've referred to the Lombard case, and this is my last point now, so to finish off, I wanted to address you on the Lombard case because it is comparable in my submission. The facts were quite different. It's a decision Mr. Justice Friedman. But if we look at paragraph 108 onwards, the nub of it appears. It says, so this is at page 442 in the authorities bundle. I don't know if it's helpful to have a tab. It's tab 18 of the authorities bundle.
No bookmarks in the electronic version.
Oh, I'm sorry.
And the new bundle of authorities doesn't go up to page 442. So which bundle of authorities is it found in?
I've got the new bundle of authorities split over two bundles, and this appears in the second, which is called 2.1.
My apologies. I've done quite well in not running into a bundle issue. Nearly 2 hours.
I'm sure we'll find it, but rather than waste time on looking at the page,
Yes.
what's the point?
So, paragraph 108 records. So the delay here was about 4 years in total, and he said the only period for which an explanation had not been provided was 17th of January 14 to 17th of December 14, so about a year. Which I say is about the same as the period here that you might look at as being unexplained. Once you take into account the time it takes to get an expert report, probably about 12 months. And he refers to various authorities about the question of delay, paragraph 110, Standard Bank, saying, delay in making an application set aside rarely appears to have been a decisive factor if the defendant could show that he had a real prospect of defending the claim against it, referring to a judgment set aside after 7.5 years where there was a real prospect of success. Then goes on in that same as Moore-Bick, or Justice Moore-Bick in this case, saying the civil procedure rules had intended to implement a change, but having regard to an explicit requirement in Rule 13.3, explicit requirement to have regard to whether the application was made promptly. There's an important point here, which is whereas that rule does require an application to be made promptly, 40.9 doesn't in terms say that an application must be made promptly. So there must be intended to be a distinction between a case under 13.3 and a case under 40.9, otherwise it would be part of the rules. So I say it's not a stronger factor, and this is what we said below, not a stronger factor in 40.9 case whether it's made promptly. Because what you're really looking at, as I think your Lordship's already identified, is whether you've got an interest or not. And if you have, then delay is probably just one of the things to throw in, or promptness is just one of the things to throw into a general consideration. He says it's not a condition in that case, not a condition, delay not a condition to be, promptness, sorry, not a condition to be satisfied. It's a factor to bear in mind alongside the merits. And where the merits, paragraph 111, he refers to a different case where Lord Justice Christopher Clark said, the stronger the merits, the more likely it is that the court is prepared to exercise discretion to set aside, despite delay. And so, in that case, Mr. Justice Friedman referred to no specific evidential prejudice which was demonstrated, and I say again that's analogous. There's a suggestion of prejudice, there's no evidence of prejudice. He said he believed that the district judge, or the master in that case, had gone wrong in their evaluation of the merits versus all the other factors, and so re-exercise of discretion, saying that because there was merits in the case, together with an adequate explanation for most of the delay, save for those 12 months, that meant the judgment should be set aside. And so I say, by way of conclusion, that's where we get to in this case. I hope I've shown why it is that Kyrrex was directly affected by this judgment, and why the discretionary exercise should fall in favour of allowing them that opportunity to be heard on a case which everyone now accepts was based on a flawed report, flawed evidence. And if that isn't done, my lord, then what we risk, in this case and in other cryptocurrency cases following this case, it is the court becoming an instrument of injustice rather than justice.
And your 10th point was to do with what order we should make, and I think we've been through that already, and you've given us a draft order.
Yes, my lord.
So we have
you've more faithfully followed my agenda than I have, my lord, but yes, I gather that I've covered that point. So unless I can assist the court any further, there's my submission.
Was there a suggestion that another aspect of prejudice was what Mr. Jones has done with the Bitcoin? Because it's not suggested that he still has it in his hands.
The judge rejected that, I think. He dealt with change of position defence. I may have to come back to you on that one after the short adjournment, my lord, but as I recall, the judge said he wasn't impressed by the change of position point.
Yes, well, it's the bottom of 46, top of 47.
I mean, what I would say, yes, I'm grateful, my lord, and what I would say is they were on notice of our claim almost immediately. So if they change their position, they've not done so in reliance on anything we've done, because we told them that we didn't consider it was their Bitcoin, his Bitcoin. And to my lord's point about the 30th of September, that's paragraph 44 of KP2, which I took the court to with my lord before. So if that answers your lordship's inquiry there.
No, thank you to you and your team.
Grateful. Thank you.
My
Yes,
lord,
Mr. Mack.
I want to begin, if I may, by going back and running through the essential facts that give rise to this appeal once again. Once I have done that, I will then turn to various quasi-housekeeping matters, points that have arisen in the course of my learned friends' submissions, on which I'll address you briefly. And then, having done that, probably by then, after the short adjournment, I'll address you on the questions of whether this appellant was directly affected, and then move on to consider whether the judge carried out his evaluative exercise in a way that this court ought to disturb. So the question which this appeal poses arises from the following facts. 1. An individual defrauded of crypto assets instructs an expert who traces the proceeds of that fraud to a wallet hosted at a cryptocurrency exchange. 2. The wallet contains assets originating from several parties. That's the finding that the judge makes at paragraph 18, 21 and 41 of the judgment in reliance on evidence from Mr. Plumpton of Kyrrex in his second witness statement at paragraph 42 on page 35 of the supplemental bundle and paragraph 69 on page 70 of the supplemental bundle. Third, the identity of those who may have rights to those traced crypto assets in the wallet is unknowable by the defrauded individual without the cooperation of the cryptocurrency exchange. Now, that is simply a feature of the terms on which the cryptocurrency exchange holds those assets on behalf of its customers. That is common ground between the experts. It's in the Another Day initial report of 2024 at page 156, and it's in the Prometheus report on behalf of the respondent at paragraph 8.2.1 on page 241 of the supplemental bundle. 4. The defrauded individual obtains a court order that the cryptocurrency exchange should reveal the identity of those asserting rights to those traced proceeds in the wallet. That appears in Schedule 2, paragraph 9 of the Information and Service Order at page 112 in the supplemental bundle. 5. The cryptocurrency exchange fails to comply with that order, but does not contest it either. 6. The individual goes ahead on the basis of expert evidence that has not been called into question by the cryptocurrency exchange and obtains summary judgment, not default judgment, for the return of proceeds traced to the cryptocurrency exchange and to a particular wallet controlled by the cryptocurrency exchange. And as your lordship saw when my learned friend took you to the order is made against the cryptocurrency exchange as a constructive trustee. In other words, as a substantive defendant, not merely somebody who is mixed up in wrongdoing by other substantive defendants, D1 and D2. 7. The cryptocurrency exchange complies with that order by transferring crypto assets from a wallet that is not the wallet named in the order. That's paragraph 13 of the judgment, page 80 in the core bundle. 8. The cryptocurrency exchange then makes an equivalent debit to the account of one customer whose assets are held in the wallet named in the order. There's no transfer between the RWRMV wallet out of which the payment is made and the Thel wallet that is the target of the judgment. The account of one particular customer, K, is debited even though the order does not specify that customer as the holder of the proceeds of the fraud against the victim, and even though the cryptocurrency exchange could have satisfied the order by debiting the account of other customers, paragraph 41 of the judgment on page 86, some of which assets were the proceeds of illicit activities. That's common ground between the two experts. There's around 1,100 Bitcoin that is identified by both experts as the proceeds of illicit activities, or could have debited its own holdings in that account. And as your lordships have heard, no explanation was given by the cryptocurrency exchange as to why this particular customer K had their account debited. That's paragraph 19 of the judgment, page 81.
Did you say that H had its own Bitcoin in the account?
Well, that is the evidence that is put forward by Mr. Plumpton, and I think
remind me who's
in the letter.
Whose expert was that?
So Mr. Plumpton is from Kyrrex. Let me find that in my notes. Yes, so Plumpton 2, paragraph 42.
Page?
It is page 35 in the supplemental bundle.
Thank you. Right, so this is the statement that we were last at.
Yes.
Quite recently.
Yes.
And you're looking now at paragraph 32.
Paragraph 42.
42, thank you.
says potentially.
It does indeed. It doesn't say that it's definitely there. The reality is we have no idea. But the appellant itself recognises the possibility that Huobi's own, I suppose, proprietary funds or funds resulting from proprietary trading may be being held in that wallet.
When it says potentially Huobi itself, as explained above, do you know what that's a reference to?
I believe that to be. I believe that to be a reference to the letters of the 19th of September and the 21st of September. Yes, if your lordship looks at the letter of the 19th of September, which begins at 283, and has a look at the paragraph, the third reason, on page 285, your lordship will there see the second sentence. Therefore, any balances on the wallet quoted by the court may well include funds of Huobi themselves or other client funds or assets held on behalf of other client account holders.
Okay, thank you.
Right. Well, we were dealing with facts.
Yes.
This is an assertion.
Well, what we know is that the account contains funds that aren't just the funds of Kyrrex.
Yes.
In fact, we know that Kyrrex's proportion of the funds in that account is actually, in that wallet is very small.
What is the evidence as to how much was in the wallet and how much was Kyrrex's?
So the evidence as to that, at the material time that the order was satisfied, appears at page 233 in the supplemental bundle.
Thank you.
Right. Whose report is this?
This is the instructions to the Prometheus expert who is appearing on behalf, who's providing evidence on behalf of the respondents. But you'll see there it's based.
Sorry, when you say the response, do you mean you?
Yes.
Right. So this is the instructions to your expert.
Yes.
Right.
And your lordship will see there that it is referring there to Kyrrex's letter. It's the other letter from Kyrrex, the second one, the 21st of September one, which gives the figure 1546 at the top of page 292.
So it's 2.4, is it? We're looking at here, 2.4?
Yeah.
And so this is the understanding of your client's solicitors when instructing the expert, based upon what Kyrrex had themselves said.
Yes.
Right. So 192 out of 1546.
Yes.
Do we know where the 1546 comes from?
Yes, so the 1546, my lord, comes from Kyrrex's letter of the 21st of September 2022, and it's at the top of page 292.
In fact, if you look at page 291, that's where the figure of 192 comes from. And then, as you say, the 1546 comes from the top of page 292.
Yes. And that figure then and indeed the paragraph of that letter is then picked up in the judgment in the court below on page 117 in the court bundle.
So something in the order of an eighth.
Yes. Yeah. So the evidence is that there's plenty of assets belonging to other people. There may also be assets belonging to Huobi. We don't know, but it's a possibility to which Kyrrex averts at the time when it's writing these letters in instant reaction to the freeze on its account, which it has become aware of on the 9th of September 2022. I think I've got to point 8 of the points I was going to just run through. 9, very shortly after the defrauded individual obtained the court order, the customer whose crypto asset holdings have been frozen, whose business is as a cryptocurrency exchange, asserts that it has been wronged by Huobi's actions because its account does not contain the proceeds of the fraud against the individual. Now, my learned friend seeks to take those letters of the 19th and 21st of September 2022 and say, well, there you are, there is Mr. Jones being put on notice that Kyrrex is potentially coming after him. But my lords, on a fair reading of those letters, what those letters show repeatedly is Kyrrex complaining about Huobi's actions. It is Huobi's unilateral decision to place a portion of our funds into a locked position that is complained about on page 290. They say, in stark contrast to the position adopted on this application in the middle of 291, that Kyrrex is not and cannot be considered to be a part of the court order and injunction in question. And they threaten at the bottom of that letter on page 293, in case Huobi fails to adhere to these requests within the next 24 hours, Kyrrex shall be proceeding legally against Huobi for the recovery of all damages suffered because of this action. Again, the second letter at 29. So that's how the position is presented. A fair reader of those letters in my submission would have concluded that Huobi was about to face imminent court action, not that Mr. Jones's judgment was going to be disturbed.
Why was Mr. Jones copied in on a fair reading?
I think Mr. Jones is copied in because the response of Huobi to the threat by Kyrrex is nothing to do with us. They're sort of disavowing any responsibility for their choices to ignore the information order and their choice as to choose Kyrrex as the person whose account is going to be debited. So, 10th. After obtaining the papers related to the action brought by the defrauded individual against the original cryptocurrency exchange, the well-resourced customer takes 18 months to issue an application to set aside the judgment obtained by the defrauded individual. Paragraph 48 of the judgment, pages 87 and 88. 11. In those 18 months, the legal owner of the original cryptocurrency exchange has ceased to exist, and there's more than ample opportunity for the proceeds of the fraud to have been moved on further, such that both tracing all the steps through which assets have been moved and enforcing any order based on tracing have become significantly more difficult and potentially exponentially more difficult. Paragraph 49 of the judgment, page 88.
That would apply, would it not, to a situation which simply restored the status quo ante? But would it apply in a situation where the contested Bitcoin was simply preserved?
It would still leave Mr. Jones in the position where if Kyrrex would prove to be right, he's been prejudiced by not having been able to investigate his position, to take alternative measures in order to see where else the
Well, that might
process
be,
of
that might be laid at the door, might it not, of his first expert, of the first expert who was his expert.
My lord, it might. I'll come back to some practical difficulties with that when I get to my short points I wanted to address.
Right, you're on the facts.
Yes. So in the light of those 11 additional facts, is the additional fact, which is not contested for the purposes of this application, that the original tracing exercise was flawed, of such overriding significance that this court should conclude the judge and the court below both went wrong as a matter of law in finding that the non-party was not directly affected by the judgment, and when refusing to set aside the judgment, exercised his discretion in a way in which no reasonable judge would have done. Such the only decision he could have come to, and therefore the decision this court must come to, is that the judgment should be set aside. Even though, and this is the point raised in the Respondent's notice, as I've shown your lordships, the non-party's original complaint was that the cryptocurrency exchange had wrongly debited its account. And the non-party has had, at all material times, a cause of action against the cryptocurrency exchange, which cause of action is not inconsistent with or adversely affected by the existence of the judgment in the present case. That's the context, my lords, in which this appeal has to be considered.
I was just reminding myself of the Respondent's notice, and that's, I think it's 22 of the core bundle.
Yes.
Right. That they should have gone against Huobi while it existed.
Yes. Yes, that was what they were planning to do immediately upon being alerted to the judgment. When one runs through it and asks what has gone wrong here, the appeal seeks to place all the blame on the claimant's expert, whereas the reality is that Huobi were faced with an order of the court that they provide information and documents that would have revealed the interest of the parties who claimed rights over the Thel wallet. In fact, my lord, when one looks, it may be helpful just to return to that information order in a little more detail than you were taken through it by my learned friend. So that information order begins at page 106 in the supplemental bundle, and it is crafted with 2 paragraphs that are material. One paragraph, paragraph 6, is a request for documents.
What page are we on?
108, my lord, of the supplemental bundle.
Thank you.
So paragraph 6 is a request for the documents, which documents to be specified in Schedule 1. And then at paragraph 8 on 109, there is a requirement that Huobi serve a witness statement addressing the matters set out in Schedule 2. And when you turn to Schedule 1, what you see is a request for information about account holders, credits to the Thel wallet, that's paragraph 5, and also details of Bitcoin addresses used by XDic Pro, who are the people who carried out the fraud on Mr. Jones, so in effect D1. And when one looks at Schedule 2, the information to be provided in the witness statement referred to, again, at paragraph 1, it's the customer accounts allocated to XTIC Pro, and that is reflected again in paragraphs 7 and 8 and 9 of the order.
How was jurisdiction established for the purposes of assuming this is the case, that there were service of proceedings outside the jurisdiction? What was the basis of it?
My lord, I think I would need to take instructions on that because I wasn't counsel dealing with the case at that stage. But it would have been open to Mr. Jones as an English resident consumer to say that he'd suffered loss as a result of a tort that caused damage in the jurisdiction. That would be one
I think you should look at page 107.
I'm grateful, thank you.
This is how Judge Pelling recites the gateways.
Yes, thank you. Yeah, it's grounds 5, 9, 15 and 16.
Yeah, but the fourth defendant, which is what we're interested in,
It's ground 3.
is ground 3. Remind us what ground 3
Necessary
is?
or proper, is it?
Is it that they're an extra defendant, added defendant?
Yes, they are. That's it. Yes, that's what ground 3 is.
What are the grounds against the anchor defendants? Are torts committed in the jurisdiction, are they?
I think so. Just me pull up my electronic copy of the white. So, yeah, 5 is interim remedy.
9 is tort.
Tort. 9 is tort. With
Damage sustained to
in the jurisdiction, which is the one that I went to instinctively first. 15 is claim against the constructive trustee. And 16 is claim for restitution.
But these are all acts committed within the jurisdiction, and presumably, if your client's a resident of a jurisdiction, that's where he sent the money from the UK.
Yeah.
Yes.
Yeah.
Yes.
Okay.
So the sequence of events then, at this particular point in time in the summer of 2022, is that by paragraph 8 of the order which you've just been taking us to, the Huobi were to provide a statement giving the necessary information by the 15th of July 2022. That there was then, I don't know that I've seen it, there was then, as recorded in Mr. Cooper's order, a supporting witness statement of Mr. Murray of the 8th of August 2022, which presumably will have informed the court about what had and hadn't been done by Huobi. And the matter then just goes ahead on the summary judgment on the 6th of September, when the court is not provided with any information from the fourth defendant, Huobi.
Yes.
I mean, am I right in thinking the exchanges don't actually generally respond to those information provision orders? I'm not saying they shouldn't, but
Well, my lord, in a matter which I've been leading my learned friend Mr. Darrell, the case of Smithers, the experience is that it varies. That some exchanges, including in that particular case Kyrrex, did respond to the court's order. Other exchanges also responded, but there were one or two that hold out. One of them, Binance, which has now located itself in the ADGM, insists that it will answer questions only posed through its proper jurisdiction. But so the position is variable, but the reality is that we are dealing here with cryptocurrency with a worldwide network of cryptocurrency exchanges which act as core nodes for cryptocurrency. But we don't yet have the developed framework for compliance with orders of local courts that one sees, for example, in relation to banks. So the approach taken particularly, as I say in the Smithers case, which I appeared, it is cryptocurrency exchanges are not yet behaving on mass kind of probity that one expects from banks, and therefore in those circumstances it's not quite become routine. Of course, it's always exceptional to serve out, but when it can be seen that they're mixed up in fraud, orders for service out are properly made in order to preserve, assist with the preserving of assets. Because one hits this fundamental contradiction that in principle, the originators of the idea of crypto assets were this would be a way of developing a decentralized financial system that enabled peer-to-peer payments to be made without the traditional intermediaries being those banks that at the time this was becoming popular were seen as having responsibility for the global financial crisis. In practice, what has happened is that many people, including some cryptocurrency exchanges such as Kyrrex, have chosen not to hold their crypto assets directly on the blockchain, but to hold them through exchanges.
Which is like banks for this purpose. I mean, they're holding other people's money and complying with their instructions. If they...
they're holding other people's property on terms which we say, on the facts of this case, look very like a bank. Because if one starts asking questions about who's got title, the answer seems to be title vests with the cryptocurrency exchange that's holding.
I think that's controversial.
I appreciate that it's controversial. It is also, in my submission, likely to be a situation where one has to look at each different crypto asset because they behave differently, and the terms and conditions on which each cryptocurrency exchange is holding different assets, and also as to what is happening in practice. Because again, at the current state of development within the industry, it is not always obvious that the way in which assets are being handled in practice aligns with what the latest iteration of the terms and conditions says. And the New York court has had to grapple with those kinds of questions in relation to bankruptcy of the Celsius crypto asset platform, and other issues are being raised in other insolvency contexts that are working their way through the courts around the globe.
All right. Well, would that be a good moment to
Yes, my lord.
break? We'll start again at 2 o'clock.
Rising,